Is liberty dying where you live? Escape to Keene at freekeene.com.
Okay, are we all set to proceed with State versus Ian Freeman?
Yes, Your Honor.
No, I put in a motion to continue this hearing today. I put that in a week ago. But I would like to have a motion, or I would like to change this into a hearing on the actual administrative inspection warrant, if that's possible. So I've been interested in challenging the legitimacy of that since I was aware of it last year.
All right, so you're withdrawing your motion to continue the hearing then?
The hearing today was supposed to be a full trial, and I would like to continue the full trial. But I would like to have a hearing regarding the administrative inspection warrant, which began this whole process in the first place.
Mr. Mullins?
Yeah, a couple of things, Your Honor. There's another motion outstanding that the court will need to deal with. It came on early in the case. It was a motion to dismiss based upon a constitutional provision. The court's order was that it would be dealt with at the time of trial. I don't know if the court wants to deal with that this morning.
Which motion is that, Tom?
In my docket, that was number 5. It came in on February 7, 2013, and it was titled a motion to dismiss, and it cited Article 10 of the state constitution. So that's one matter still before the court. With respect to the continuance, we would object to the continuance. Mr. Bernard, I know Mr. Bernard prefers to go by Freeman. I'll let the court decide which should be addressed. But he's requested a continuance. He's obviously here this morning. With respect to the motion on the administrative inspection warrant, we did file an objection to that. We don't believe there's any basis for that at this point, and issues with respect to the administrative inspection warrant would be something that would come out as a matter of the facts that are presented before the court on the motion to, on the request to enforce the city ordinance.
Well, I guess, Mr. Freeman, the question is, do you go by Freeman or Bernard?
Yes, Ian Freeman, thank you.
Mr. Freeman, it sounds like there may be some factual information necessary to make a determination about your motion.
Which motion? I'm sorry, there's like 3 right now. So.
The motion for the hearing on your administrative inspection warrant.
Yeah.
Okay. What other motion besides the motion to continue are you talking about?
Well, he brought up the motion
to dismiss, Your Honor.
From February 7th.
Is that a motion that is still pending?
Yes, Your Honor. The court issued an order on (3/15/2013). Court's order already motion to be addressed at trial. It's a handwritten note on the copy of the motion that was filed, Your Honor. It says to be addressed at trial. And I believe it was signed by Judge Berg, if I read the signature correctly. And we did file an objection to that, Your Honor.
Okay, I haven't reviewed that. I'm having a hard time locating it here in the file. Is that a motion that you're prepared to argue today, Mr. Freeman?
The motion to dismiss?
Yeah.
Sure, I'd be happy to make
Okay, what was the basis for your motion to dismiss then?
Article 10, New Hampshire Constitution, the right of revolution. Are you familiar with it?
No.
Okay. Well, I'll share it with you. The right of revolution, government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted, and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right, ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. And
so how is that applicable to this situation?
Well, I'm engaged in a peaceful revolution against the men and women calling themselves the city of Keene in this case, as well as the United States, the state of New Hampshire. As a believer in property rights, I believe I own my property. And as a landlord, I want my tenants to be happy and safe, and feel safe living in their home. So I'll take steps that are necessary to achieve those goals. And I'm happy to listen to suggestions from people who are experts in fire safety. in order to do that. However, I don't appreciate being threatened, and I will not accede to demands that I feel are ridiculous, expensive, and unnecessary, especially when I have my tenants agreeing with me. Now, Fire Chief Gary Lafreniere, who's a very nice gentleman sitting in the room here today, will testify that I did take steps to increase the fire safety in my tenants' homes.
Objection, Your Honor. I want to, if you'd like to do that.
Yeah, let's
before-
address your argument here first about the constitutional issue. Mr. Mullins, what do you want to say in response to that?
I did file an objection, Your Honor, that's in the record, if the court can't find it. But essentially, the position that the city takes with respect to Article 10 is that it's just not relevant or germane to the issue before the court. I did cite the case of Nelson v. Wyman, the Attorney General's, the Attorney General, 99 New Hampshire, 33, 1954. And as the court says in that, it's not a broad and unlimited right of insurrection and rebellion as to permit any group which is dissatisfied with the existing government to lawfully attempt to overthrow the government by force or violence.
I'd like to object to that.
Well, hold on, Mr. Freeman, you had your chance. Just a minute. Mr. Mullins?
Your Honor, from the city's perspective, what we're talking about is an ordinance, city ordinance based upon the life safety code, which has been adopted by the state. It's purely a regulatory issue. I would suspect and would hope that even in Mr. Freeman's society, should it come to fruition, that it would have an interest in protecting life and safety and have some sort of regulatory structure with respect to a fire code. That's what we're talking about. We're not talking about the political ramifications of the political bodies before the court. That's basically what we're here for. We don't think the article is relevant.
Anything else, Mr. Freeman?
Yes, I'd like to object to his interpretation that I intend to overthrow anyone. I'm a peaceful person and I had no intention to overthrow. But the basic gist of this motion, which I wasn't able to get through here, was that I've been targeted for my activism. I'm a known activist in the area here. And Fred Parcells, who is the man who brought some of this action against me, is with code enforcement in town. I've had a history with Fred that has been mostly pleasant on a personal basis, but ever since he was hired as code enforcer, he's been coming after me. And so I can look at the history of me owning this home in Keene. Prior to Fred being hired as code enforcement, I hadn't heard hide nor hair from code enforcement in years about my property. Then all of a sudden, when Fred gets hired...
Mr. Parcells will be taking the stand, and to the extent that the court finds any of this relevant, we can have that discussion with the court.
The point is, it's a person. It seems like a vendetta against me for being an outspoken activist, and I've got a long
I don't know
history.
anything about that at this point, Mr. Freeman, but if there's going to be evidence introduced on that subject, I'll certainly take that into account before ruling on the motion.
So, do you
So
want me-
I'm not going to rule on the motion at this point. I'll defer ruling on it until after I hear more.
Your Honor, I guess I would request some clarification with respect to that. I mean, I expect that Mr. Freeman will attempt to elicit testimony from Mr. Parcells with respect to what he thinks may have happened in the past. I'll certainly object to that. But to the extent that the court wants to have a full-blown hearing on whether Article 10 attaches to this, then I need to raise that question with the court.
We don't need to have a full-blown hearing on that. I will take into account what both of you have said about the applicability of the article. If there's anything that is produced by the testimony that reflects on that, I'll take it into account, but I don't think we need to hear any more about it.
Thank you, Your Honor.
Okay, so, Mr. Freeman, as far as the hearing on your motion for the administrative inspection warrant, do we need anything further about that before we start taking testimony on the underlying issue, on the trial of the underlying charge?
Well, yes. Regarding the administrative inspection warrant, it's my contention that it was issued in error, and that is based on RSA 153.14.2. This is one of your society's rules that says that the fire chief may inspect all buildings, excluding single-family dwellings and multi-unit dwellings containing 2 units. Now, in the city's own, as you see in the motion there, the city's own notice of violation they issued me after they had gone through this warrant. They had come through my property and essentially raided my tenant's home. They indicated in their notice of violation that they still have the home classified as a single dwelling unit. So by statutes, by your statutes, the fire chief never should have been allowed to come in and inspect. The city's argument in their objection is that, well, we believe that you were running a lodging house, and so therefore the fire codes would apply. But the purpose of the warrant was to get in there so they could determine whether or not the lodging house was being operated. So they had not yet made the determination that a lodging house was being operated. The legal status of the household was never changed, and to my knowledge still has not been changed to a lodging house, nor could it be changed. I've never been charged with running a lodging house or accused of running a lodging house. So they couldn't have come in, the judge, Mr. Burke in this case, could not have ordered the fire chief against statutes to do something that he statutorily prohibited from doing.
Rollins?
Yes, Your Honor, and I will be submitting, I'm sure the court will take judicial notice of RSA 153. I do have a copy of the materials that will be submitted to the court. I think it's important for the court to note a couple of things. The notice of violation did state that Mr. Freeman's property has been, and as far as the city was concerned at the time of the administrative inspection warrant, classified as a single-family residence. The information that will be testified to by the parties here on behalf of the city will indicate that the city had probable cause to believe that the property was not in fact being used for that purpose. Once it wasn't being used for that purpose, then that created a potential zoning violation. The issue with respect to the 153 does not allow the fire inspector to go into what is clearly established as a single-family home or a multi-family home. The issue here was whether or not there was probable cause to believe that the property was being used outside of those two classifications. The administrative inspection warrant, as part of the materials we'll submit to the court, will be part of the testimony. That warrant that was submitted to the judge did include evidence sufficient for the court at that time to establish that the property was being used other than for its listed purpose. At that point, the fire inspector has the right to go in and make a determination as to whether or not it is actually being used in another manner than was permitted. And we would submit that the evidence will show that that was in fact the case, that it was not being used as it was being represented. So at that point, the judge issued the administrative inspection warrant. We went in for that purpose. The question for the administrative inspection warrant, is the judge is clearly aware, is not to make a determination in the front end as to whether or not a violation has occurred, but to present enough information to the court for a determination as to whether a warrant should be issued to determine whether or not there is a violation. The fact is that the administrative inspection warrant and the inspection that happened as a result of that had revealed that the property was in fact being used as a single-family home. We wouldn't be here at the moment.
Sounds like it depends on the facts then, Mr. Freeman.
Well, what it sounds like to me is that if they wanted to make the argument that, they claimed in front of the court they had probable cause of lodging house happening at this particular location, they would have then been able to get an administrative inspection warrant to inspect for the purposes of determining whether a lodging house was actually occurring. So they had things that they believed were pointing to that, but they didn't have any real evidence or proof. And so the warrant, it would have made more sense had it simply authorized an inspection for the purpose of verifying the claims about the lodging house. But in addition, they brought in the fire chief, and he's prohibited from, by RSA 153, from inspecting single-family homes, which is what this was at the time that that was issued. And it's never been changed from that status. They've never made the allegation that it's a lodging house. They're just claiming that it's a lodging house with no evidence whatsoever that it is or was at the time of the raid being used as a lodging house. If they could have claimed it was a lodging house and brought some sort of action about that, then they may have had a reason to bring a fire inspector in. Again, this is according to you guys' statutes and rules and ordinances and such. I mean, I don't believe that, I think it's outrageous that strange people are coming through my tenant's home in the first place without any real crime actually being committed here. But do you understand that the time frame that I'm laying out, essentially they hadn't proven anything about it being a lodging house, so therefore it was still a single family dwelling, and therefore by RSA 153 the fire chief should not have been allowed to inspect that.
Okay, well, I'll make a determination about that based on what I hear as evidence about the basis for their asking for the warrant. So, sounds like we need evidence on these issues.
Which is why I wanted to have the hearing on the warrant.
We're not going to do this twice. We'll hear the evidence that they produce that is used to support their request for the warrant. And at the time when we get to the end of that evidence, up to that point, we'll make a ruling about whether or not the case will go forward beyond that point.
I see. So I'd still like to motion this continued until July. I've been out of town a lot, and I will continue to be traveling in the next few weeks. So I put in that motion a week ago. I've not heard on that.
What is it that you don't know or that you don't have today to be able to proceed on that?
I just would like some more time to look through, the various evidence that has been presented. I got a stack of discovery from the city here in this case.
How long have you had the discovery?
Approximately a week, 2 weeks.
14 days prior to the date of the hearing, Your Honor, in accordance with the rule.
And I was out of town on business for several days through those 2 weeks.
Mr. Mullins? Any objection to the continuance request?
Yes, Your Honor, we're all here. He's here.
Well, I understand that, but...
Witnesses are here.
I've not.
The other issue from the city's perspective, Your Honor, is that this matter has now been going on since last July, to the extent that there is a violation at this point, and the city needs to take action to correct that. I mean, this is a life safety issue, Your Honor. Mr. Freeman has already represented, he has tenants in the property, he's used that word several times. The evidence will indicate that the ordinance in the city requires that if you have a rental property, you have to have proper fire protection measures in place. He doesn't have those. It's in the city's interest to make sure that that happens sooner rather than later. Again, if the property is being used in violation of the ordinance, keep in mind that there's a no trespass order issued by Mr. Freeman. He hasn't allowed us back into the property, he hasn't invited anybody into the property. We're going on the assumption that the status quo that existed at the time that the notices of violation were issued exists.
Okay, well then, does it make sense to hear the evidence up to the point where the warrant was issued to determine whether or not, in fact, it was appropriately issued?
Well, I guess that's up to the court's discretion to do. It seems to me that at that point, we're halfway through this process anyway. I would suggest to the court that the judge that reviewed the administrative inspection warrant, the material that was submitted, the affidavits that were provided, have the discretion to issue the warrant at that point, and it's moot now to determine whether or not the administrative warrant should have been issued or not. The fact was it was issued by a court of competent jurisdiction by a judge who reviewed all of the materials, who presumably was acting in accordance with his legal standard and issued the warrant.
Well, I guess my question for you on that, Mr. Mullins, is: are you saying that any time, say, a court issues a search warrant or an arrest warrant, that warrant can't be challenged at the time of trial?
Well, Your Honor, I would suggest that the time to challenge the warrant would have been prior to this point, but if the court wants to entertain the motion to challenge the warrant, that's within the court's discretion. I'm just suggesting to the court that the court would have to make a determination in retro at this point, based upon the information that was provided to the prior judge hearing the matter, that he acted incorrectly under the law.
I would have loved
That's
to
a
have
legal
challenged
question.
this warrant previously and had
Okay.
intended to do so.
Well, I'm prepared to hear the evidence that was used to substantiate the issuance of the warrant, to determine whether or not the warrant should have been issued. And at that point, we'll determine whether or not we're going to proceed any farther than that.
That's fine, Your Honor.
Okay? So, why doesn't the state go forward then with its evidence up to that point? We'll give Mr. Freeman a chance to cross-examine any witnesses that are called for that purpose, and then we'll decide where we go once we've heard the evidence that leads up to the point where the warrant was issued.
That's fine, Your Honor.
Just to clarify, we're hearing on the administrative inspection warrant. This is not the actual trial that we're engaging in right now, correct?
Well, I don't know how much farther than that we're going to go today, but we're going to hear at least that much of it today.
So long as I get the chance to get their witnesses and ask them if we go to trial, just want to make sure I'm clear on
Well, I don't
what's
think we've
happening.
made a determination yet how
Okay.
much farther than that we're going to go.
Got it.
But we're going to go that far. Yes.
Okay.
Are you ready to proceed, Your Honor?
I need, I don't have anything. For
Yeah,
you.
we go ahead.
If you wouldn't mind, please. But yeah, why don't you call your first witness?
May I approach, Your Honor?
Yeah.
This is a document, a set of documents that have been provided to Mr. Freeman, organized in a chronological manner. It does contain the information up through the administrative inspection warrant, including the administrative inspection warrant, Your Honor. What I intend to do with a witness, and Mr. Fred Parcells, I'm going to call Mr. Parcells to the stand. What I intend to do, Your Honor, is walk through with Mr. Parcells the first documents in this folder up for the administrative inspection warrant.
All right, sir, would you raise your right hand? Please do swear your testimony here will be the truth, the whole truth, and nothing but the truth.
I do.
Have a seat if you would, please. And would you begin, sir, by stating your full name and spelling your last name, please?
Frederick B. Parcells, Parcells.
Thank you. Your Honor, may I approach the witness?
Yes, please.
Mr. Parcells, I'm going to hand you a copy of this folder as well. I'll be asking you to go through it with the court. You might want to use the table. Mr. Parcells, you stated your name for the record. I appreciate that. Are you currently employed?
I am.
And where are you employed?
I am currently employed by title as a part-time housing inspector for the City of Keene Code Enforcement Department.
And would you please briefly explain for the court what those duties entail?
In that capacity, I am involved with housing standard issues under Keene City ordinances, things such as heating, electrical, maintenance, plumbing, structural matters with regard to structures. As well, I deal with property issues, the outside of buildings, so to speak, relative, basically aesthetic matters, parking issues, lawn overgrowth, trash, dumpster situations. And lastly, and to a lesser degree, I deal with zoning matters, such as the issue at hand today, specifically the city's belief that a property is being used in a manner not consistent with the zoning district that it may be in. And lastly, under the zoning codes, I deal with sign issues, banners and sign locations and things of that nature.
All right, thank you. Are you familiar with 75 Leverett Street?
I am.
Do you know what zone 75 Leverett Street is contained in under the city zoning ordinance?
Low density.
And could you please briefly explain for the court what low density is?
Low density primarily has 8 uses that are allowed in it. The two that come to mind for most people in low density is single-family home and or a duplex or a two-family home. Under city ordinance, there are 8 total uses. The single-family, the two-family are allowed. There's also light farming, so to speak, allowing small animals, and historic areas where the public is open to the public. The other 5 uses are by exception. You would have to go to the zoning board and seek a special exception for the other uses, such as a group home, as an example. But that's by special exemption only.
All right, thank you, Mr. Parcells. Your Honor, just for the court's ease, we have included documents number 17 and 18. The court will notice in the beginning of the book there is a table of contents. Each one of the documents is date stamped, beginning with the first relevant page and ending at the last. Documents 17 and 18 appear at pages 66 to 76 and 77 to 78 of the booklet. Those are the relevant zoning provisions with respect to this discussion. It includes the definitional requirements that we're going to be talking about. We would like to admit those, Your Honor.
Mr. Freeman, any objection?
No objection.
Thank you.
Thank you. Mr. Parcells, are you familiar with how 75 Leverett Street was classified by the city prior to the issuance of an administrative inspection warrant?
As a single-family home.
And as a single-family home, that's permitted in the zone?
Yes, it is.
Did you have occasion to learn or come to some belief that 75 Leverett Street was not being used in that capacity?
I did.
Would you explain for the court how that knowledge came to you?
In the course of my job, Your Honor, I'm required to attend on a periodic basis what we commonly refer to as neighborhood group meetings. There is such a neighborhood group known as the West Central. That's a geographic designation. West Central group that primarily covers the area in which Mr. Freeman's property, 75 Leverett Street, is located. This is a group of neighbors, people who live immediately next door and/or in a certain geographic radius of the property in question. And they meet periodically, and both I have a coworker, but I attend these meetings. And it was during one such meeting on or about February 17th of 2012 that a group of the neighbors, members of this particular group, were present, and not by name because they prefer anonymity, but they brought to my attention via a complaint, if you will, that they believed that the property at 75 Leverett Street was being used as more than just a single-family property, based on their observations of seeing cars coming and going, a great number of cars, a great number of people, individuals, both male and female, coming at all days of the week and all hours of the day. And anecdotally, this group of individuals making up the neighborhood group said, we think that they're renting space there, that there's a lodging house or something of that nature going on. So I took that information in on or about February 17th of 2012.
Now, you use the word lodging house. Does that term have significance to you as somebody who has a responsibility for enforcing the zoning ordinance?
Well, in that, if in fact that existed at 75 Leverett Street, it would be contrary to the low-density zone requirement that the property is situated in.
Mr. Parcells, I want to direct your attention and the court's attention to page 71 of the binder that I've given you, and ask you whether or not the zoning ordinance includes a definition of lodging house.
Indeed, it does.
Right. And could you just summarize for the court what that definition entails?
It's a dwelling for more than 4 unrelated persons, which lets sleeping accommodations for a transient or permanent basis without personal care services and with or without meals, but without separate cooking facilities.
And I also believe you used the phrase, the word tourist home, directing your attention to page 75 of the packet of materials. This again, for the court's application, is part of the zoning ordinance for the city, a portion of which is attached. And is there a definition for tourist home?
Yes, it reads, a tourist home means a private home with rooms leased for overnight transient accommodations, and then it goes on to talk about motels, apartments, etc.
Are either of those uses permitted in the low-density zone?
They are not.
Now, with respect to after this meeting that you had with the neighborhood association, what did you do at that point?
I started to do some research, if you will, because I had some vague awareness with regard to the property in question that there was I'm not sure how to phrase it, a group, an association, something of that nature, called the Keene Activist Center. And so I went on the internet and did a little research on the Keene Activist Center and came up with certain writings posted and certain photographs which seemed to agree with the observations being made by the members of the neighborhood group that perhaps rooms or beds or bunks or however you would define it were being let out for some kind of financial remuneration. There were photographs seemingly depicting individuals reclining in what I would call a bunk bed or bunk beds. So there seemed to be a consistency there to what the neighbors had already told me.
Now I'm going to direct your attention to page number 1 of the set of documents. Now that you had this information, actually page number 2, I apologize. After you had this information, what did you do with it?
I communicated via email to Mr. Freeman, I apologize.
And why did you communicate by email?
Because he didn't want to talk with me. I couldn't go on he didn't want me on his property, and we had agreed the day prior on the email occurred on May 3rd, but the day prior on May 2nd, and I wrote here, per your request in your last email response to me yesterday, Wednesday, May 2nd, and contrary to my preference, I will communicate to you via this email message that information which I would have preferred to convey to you in a face-to-face manner.
Did you request the opportunity to inspect the property to make a determination as to whether or not the evidence that you had gathered with respect to the use of the property was accurate or not?
Yes, I did. I wrote, specifically, I wish to make you aware of the city's belief that your property located at 7375 Leverett Street is being used as something other than a single or two-family property as allowed under the city's zoning ordinance. Specifically, based on the evidence we have reviewed, the city believes that you are running a tourist home or some other business providing overnight transient accommodations. You are being respectfully asked to consent and to allow for a voluntary inspection of that side of your property listed as 75 Leverett Street so that a determination can be made as to the validity or not of said belief. Thank you for your consideration of this matter, Fred.
And did you receive a response from that?
I did. On the same day, May 3rd, Mr. Freeman responded, Fred, I am certainly not doing any such thing as I am quite busy with my radio business. I am sure you are aware that I live at 73 and tenants live at
Mr. Parcells, I'm going to interrupt you, I think. I don't think the court needs us to read the entire document into the record. I'll submit to the court for that. The question
In essence, he said no.
He said he would not let you inspect.
That's correct.
All right.
No, I'd like to object. I mean, he did read through his email, and mine is fairly short.
That's fine, Your Honor. I didn't mean to interrupt. I just would like to remind Mr. Parcells that the court has the record. If the court would allow that, it does seem fair to me because he did read his into the record.
Go ahead, Mr.
Thank you.
Parcells.
Thank you.
Starting over. Fred, I am certainly not doing any such thing as I am quite busy with my radio business. I am sure you are aware that I live at 73 and tenants live at 75 as per our previous discussions. If you believe they are violating an ordinance, please send me the ordinance in question and the evidence upon which you are basing this accusation, and I will be happy to present it to them. Excuse me. I will respectfully decline to allow an inspection. My tenants have a right to privacy. If they are not hurting anyone or upsetting my neighbors, then it is none of my business what they do over there. All the best, Ian.
Thank you, Mr. Parcells. Your Honor, I'd request that document number 1, consisting of those 2 pages, be admitted.
Any objection, Mr. Freeman?
No objection.
All right, thank you.
All right, Mr. Parcells, after that occurred, did you receive another communication from Mr. Freeman?
The criminal trespass notice,
Did you receive a criminal trespass notice?
I received it through the city manager's office here, not directly.
All right, I'm going to direct your attention to page 3 of the materials. And have you take a look at that?
Yes, sir.
Do you recognize that?
I do.
And could you explain for the court what your understanding is of that document?
That I and other employees of the city of Keene were prohibited from stepping foot upon the property at 7375 Leverett Street henceforth.
All right. Subsequent to the, Your Honor, I'd like to request that the no trespass order be admitted into the record.
Any objection, Mr. Freeman?
No objection.
Thank you.
Mr. Parcells, subsequent to your review of the information that you had available to you, did you have any other discussion with city staff with respect to what may have been going on at the property?
I did. I presented basically to the assistant city attorney.
Well, Mr. Parcells, I'm going to direct your attention more directly. Did you have any conversation with the fire department?
I did, I'm sorry. With Captain Lafrenia, the fire inspector for the Keene Fire Department.
Why would you have had that discussion with Captain Lafrenia?
Well, there were 2 issues at hand in my mind. One was the neighborhood's concern that perhaps there was a violation of the zoning ordinance in that there was a lodging house or something of that nature occurring there. And then if that were the case, the next concern, which is more in the purview of the fire department, is whether or not there's adequate fire protection, specifically smoke detectors, carbon monoxide, et cetera.
All right. Now, turning your attention to page number, it's actually page numbers 4 through 22 of the document set that I provided to you. I'd like you to take a moment and look through pages 4 through 22. Oops. Yes.
Yes, sir.
Are you familiar with that sort of paperwork document?
I am.
All right. And can you briefly explain to the court what that document is?
It was a request for an administrative inspection warrant to be issued, a request from your office, the city attorney's office. It contained the affidavit presenting to the judge the belief of the city that there was a violation, two violations perhaps, one the zoning violation and the other perhaps inadequate fire safety protection. That request was accompanied by an affidavit by Captain Lafreniere of the Keene Fire Department delineating his beliefs in the matter, and then an affidavit by myself delineating my beliefs and my findings relative to the request for the inspection. And then there was another copy of the trespass notice issued to the city manager's office. There was some writings by
I'm going to ask you to go through those in detail in just a moment, but in general, this is the packet of materials that was submitted to the court as part of the administrative inspection warrant request.
Yes, sir.
And it contained an affidavit from you and an affidavit by Captain Lafreniere.
That is correct.
Now, the administrative inspection warrant was requested after the no trespass order was issued, is that right?
That is correct.
And it was issued after Mr. Freeman had stated both verbally and now in writing that he wouldn't allow anybody on the property.
Yes, sir.
Now, taking a look at the administrative inspection warrant, I think you testified, I believe you testified that part of the concern that you had was whether or not the property was being used as a lodging home or a tourist home. Is that right?
That is correct.
Now I'm going to direct your attention to page 17 of the document set, which is part of the request for administrative inspection warrant. Could you briefly identify what this document is?
This is a copy of a finding that I found on the internet, referred to here as the Shire Society Forum, and it's entitled HTTP Forum Shire Society /housing/visiting Keene -stay at the KAC, which I believe means Keene Activist Center. It was posted apparently, or it's titled "Visiting Keene?" ? Stay at the KAC! It was posted by a Pete, E-Y-R-E, not sure how he pronounces that, on January 4th, 2012 at 12:44 and 27 seconds p.m. on that date. It contains writings. It starts out, does Your Honor want me to read this verbatim? Or?
It's up to the court, but I'll let the court review the record. I'll ask specific questions with respect to the document, Your Honor. I didn't mean to step on Mr. Freeman with respect to the last one, but I think we'd be here for a
Are
while.
you asking to introduce this document?
Yes, I am going to ask to introduce this, Your Honor.
Mr. Freeman, any objection to that?
I have no objection.
All right, so I have the document.
Yes.
You want him to?
Yes, Your Honor. Thank you. Mr. Parcells, directing your attention to the middle of the document, does it indicate whether or not there's some payment expectation or request or belief?
That's my belief that that's what it speaks to. It says minimalist, ? Claim a couch for a donation of 15 FRNs, which I think means Federal Reserve notes, /night. And then the next line down states, need a little more privacy, sleep in the bunk room for a donation of 20 FRN /night.
So what did that indicate? Let me ask you this question first. Based upon this document, did you have any belief that this document was associated with 75 Leverett Street?
I did have that belief because, again, I had knowledge, or at least a belief, that the Keene Activist Center was located at 75 Leverett Street, based on prior actions and interactions.
Prior actions and interactions with who?
Mr. Bernard, Mr. Freeman,
With respect to this specific property?
with respect to this specific property.
Thank you. Excuse me. So with respect to this document then, did you form an opinion based upon the contents of the document as to your investigation of the property?
Based on that and more that I
Well,
also
yeah, I'm
found. But
talking
yes,
about this one in
but
particular.
certainly that seemed to agree with the neighbor's observations that there was more than just a single-family residence occurring at that property. That was consistent with their beliefs.
All right, was this document submitted to the court
It was.
as part of the administrative inspection
Yes,
warrant?
it was.
I'm going to turn your attention to page number 19 of the document set,
Yes, sir.
and ask you if you can identify what this document is.
Also on the internet, under a Facebook, I found a posting entitled Keene Activist Center. And it goes on to list some information relative to that.
Thank you, Your Honor. Your Honor, I would request that these documents actually do form the administrative inspection warrant as a whole, Your Honor. I need to go through them individually with respect to what the court wants to do. But if there's no objection by Mr. Freeman, I could request that the administrative inspection warrant and its attachments be admitted.
Mr. Freeman?
I'm not
These
sure.
documents, let me ask you this, are these documents already in the court's file?
They were part of the administrative inspection warrant that was submitted to the court, yes, Your Honor.
Okay, you're referring to pages 4 through 22.
Yes, Your Honor.
Okay. So I guess the request is then to admit those documents as the basis for issuing the warrant?
Yes, Your Honor.
Mr. Freeman, that's the claim that's being made. The contents of those documents, pages 4 through 22, were the basis for issuing the inspection warrant.
Yeah, I have no objection to those being admitted.
All right, thank you.
All right, thank you, Your Honor. And Mr. Parcells, back to page number 19. Let me ask you, did you personally pull this down off of the internet?
I did.
And did you pull it down as part of your prior inspection of the property?
Yes, sir.
And to summarize for the court what you found is, or what that document meant to you.
It seemed to be more evidence of the neighborhood belief and fast becoming my belief that rooms were being rented or let out for some kind of charge, if you will, financial charge. Primarily the last line, or one of the last lines, that want a place to crash, underlined, while checking out Keene. Again, that seemed to be consistent with the other writings found on the other website about if you're staying in Keene, you need a place to stay. Here it is.
And again, was this document consistent with the use of the property that the city understood as a single-family residence?
It was not consistent with a single family, no.
All right, then I'm going to turn your attention to pages 20, 21, 22 of the administrative inspection request, and ask you to identify those.
These are photographs that were taken off the website and off the Facebook for the Keene Activist Center. Page 20, there, I don't know how good Your Honor's photograph is, but a clearer photograph would depict what appears to be a wooden 3-level, I'll refer to it as a bunk bed, if you will. And in a clearer picture, you would see the images of 3 males depicted reclining at each level. That's page 20. Page 21 appears to be more of a metal 2-level bunk bed type structure with nobody reclining or on that structure. And then page 22 depicts 2 males sitting on what appear to me to be couches in a room within the property in question.
All right. And those were photographs that you located on the internet, is that right?
Yes, sir.
And your understanding was that they were in connection with the Keene Activist Center?
Yes, sir.
And you had a prior understanding and belief that that was located at 75 Leonard Street?
Yes, sir.
Now, finally, Mr. Parcells, I'm going to ask you, at least with respect to this set of documents, to look at page number 19, I'm sorry, 18 of the document set.
Yes, sir.
Can you identify this document?
This is just a page that I printed off the internet and given its location just after the Shire Society Forum page, It's my belief that it was attached as part of that page, and it states Keene Activist Center, February 29. It doesn't show a year. And it states, meet the new crash space names. And then there is a listing of 1, 2, 3, 4, 5, 6, 7, 8, 9. They're self-identified as bunks, or couch, or futon, metal bunk, triple bunk, etc. And there are 9 with individual names. If you want, I can read them.
No, that's fine.
It's on the record.
All right. Now, in connection with this request, your affidavit appears in the document set, is that right?
Yes, sir.
All right. And did you accurately summarize your review and investigation of what you understood to be occurring at the property at that point in your affidavit?
Yes, sir.
And did you, at least for purposes of the affidavit and the request for the inspection warrant, have a preliminary conclusion with respect to the use of the property?
It was my belief, based upon the input from the neighborhood group, as well as my findings, that there was something other than a single or two-family house occurring at 75 Leverett Street, more specifically a lodging house, or by some other name, a location where rooms or beds were being let out for a financial charge.
And did you share this information with the fire department?
I did.
Specifically with Captain Lafreniere?
I did.
All right. And Captain Lafreniere drew his own conclusions with respect to those, didn't he?
He did, and filed his own affidavit.
All right. And we'll discuss those with Captain Lafreniere at this point. So you submitted this to the court. Did the court ultimately grant a request for the administrative inspection warrant?
It did.
All right. Now turn your attention to page 23 of the document set.
Yes, sir.
Can you just briefly identify what this document is?
This is the warrant issued by presiding judge Edward J. Burke on June 13th, 12, to allow for an administrative inspection of the property in accordance with all applicable laws at 75 Leverett Street.
Your Honor, I request, this is not part of the prior document, so it's a separate document, request that this be admitted into the record.
Mr. Freeman?
Only with the standing objection to the warrant itself being issued in your.
All right, very good. Thank you.
Okay, thank you, Your Honor. And then, this Captain Lafreniere signed this. So as a result of the administrative inspection warrant request being issued, you went to the property, is that correct?
Yes, sir, on June 14th, the next day.
All right, thank you. I have no further questions at this time.
Okay, we're talking about the basis for issuing the warrant. So, Mr. Freeman, do you have any questions for Mr. Parcells about anything he's testified up to this point?
Yep.
Excuse me, Your Honor, would like to clarify that there were two, the court is clear, there are two participants in this process. The city will still need to call Captain Lafreniere to the
I
stand.
understand.
So based on your testimony, may I call you Fred?
Yes, you may.
Fred, you were the one who initiated the investigation into 75 Leverett Street.
To the extent that I was the one in receipt of the complaint from various neighbors, and that I, in the performance of my duty, followed through on that, yes.
Now, you were using the term the neighborhood earlier, but what you mean is specific individuals who live in the general vicinity when you say that.
It's a neighborhood group, which is comprised of individuals who live in the immediate vicinity.
Were all of the members of the group complaining to you, or a limited number of them?
I couldn't testify to that now, enough of them, but
Can you make a
I would
guess?
say probably not all, but
How many? Can you count on one hand?
I don't know, sir.
Okay. And you said you can't reveal the names of those people?
That's correct.
Isn't that a violation of my right to be able to face my accuser?
I am complying with
Objection, Your Honor, that's a legal question. I would suggest that at this point, for purposes of this proceeding, Mr. Parcells is the individual that's bringing the complaint.
If I may, I've had a history with the City of Keene where it turns out that City of Keene employees who live in the immediate vicinity of my home are the ones who are issuing
Objection, Your Honor,
complaints.
there's no relevance to the question of whether or not they're there. If they were here, he could ask that question at this point.
Well, I guess it sounds like the question is, does Mr. Parcells have to testify about who he may recall as the individuals who reported the alleged use of the property as a lodging house.
I understood the question to be that I think Mr. Freeman is going to try and argue that he's being persecuted by the city, and I don't think that that's relevant to this particular inquiry at this point. That's how I heard the question being asked.
Well, what's the question, Mr. Freeman? I mean, what information are you looking here for Mr. Parcells?
I would like to know who the accusing parties were that brought the complaint, the alleged complaints to Mr. Fred in the first place. As I mentioned, there was one issue, only one, before Fred was brought on board as a
Your
code
Honor,
enforcer.
with all due respect, this is a formal proceedings. I'm addressing Mr. Freeman by his given last name, which he's requesting. I would request that he address Mr. Parcells as Mr. Parcells.
Fred's already given me permission.
Oh, okay, let's do it. Let's do it that way, though. Whether he says it's okay or not, let's use people's last names in addressing them here.
When I address him directly, may I call him Fred, and then when I talk about him to you,
Call him Mr. Parcells, if you would.
Fair enough.
Mr. Freeman, I'm going to call you Mr. Freeman.
Fair enough. In a previous occasion, when I was actually here in court for another matter back in 2008 with a previous code enforcer, I was back in, we were having our hearing, and the code enforcer did not want to reveal who the person was that had made the allegation against my property, but Judge Burke did force him to reveal that information because, you know, in America you're supposed to have the right to at least know or face your accuser. And it turned out that the accuser in that case was a city employee, which seems to me to be a conflict of interest, that someone who's working for the city shouldn't be the ones who are bringing complaints to the city. So I would like to know who the people were that brought the complaint.
Okay, Mr. Mullins?
Yeah, I do have to respond to that, Your Honor. Just because an individual happens to work for the city, and I'm familiar with the issue that Mr. Freeman is raising, and that individual did see and report a violation of the Housing Standards Code. Just because individuals are employed by the city of Keene does not mean that they don't have the right to use the same processes and procedures that are available to everybody else in the city.
Well, I guess the question at this point is, are you objecting to Mr. Parcells disclosing who he may recall were the actual individuals who reported these alleged violations?
I think I'm going to leave that up to the court's discretion. I will let the court know that under RSA 91A, there is some question as to whether or not individuals who want to make anonymous complaints may remain confidential. That issue has not been clearly decided by our state Supreme Court, but it is one that some people believe is appropriate to maintain confidential. But I'll leave it up to the court's discretion.
Okay, well, I'm going to rule that if Mr. Parcells has any recollection of the individuals who may have been the ones at that meeting who had concerns about the use of 75 Leverett Street, that he disclose that information. So.
Your Honor, a year and 4 months later, the only thing that I can clearly testify to is that, A, I don't remember names specifically because I didn't write them down because they wanted to be anonymous. But B, to the best of my knowledge, not a one of them was or is an employee of the city of Keene in any capacity.
Okay, so you don't remember anyone?
Not specifically.
Do you recall generally how far from my home? Were they adjacent neighbors? Were they down the street neighbors?
I don't know specifically because I don't say, well, where do you live and how is that relative to the property? They were in that general stone throw neighborhood, if you will. A good arm could probably hit some of their windows a distance.
Okay, so in the discussion you've been having with the attorney here, you've been talking about lodging house, tourist home. The objection, most recent objection filed by Mr. Mullins stated that the property was in fact being used as a type of lodging house or tourist home. Would you agree with that assessment, Fred?
That seemed to be, that's my belief based on my findings and observations.
Now, let's see. So Which one was it? Was it a lodging house or a tourist home?
Your Honor, I'm going to object. I understand where Mr. Freeman wants to go with this, but we're starting to bleed over now into the other part of this process. I think the question that the court wanted us to focus on was whether or not at the time of the issuance of the administrative inspection warrant, there was sufficient probable cause for the issuance of the warrant. I did not ask Mr. Parcells any questions with respect to what he observed after he went into the property, because I understood that the court didn't want to get into that until it made a determination as a matter of law whether there was probable cause to issue the warrant in the first instance.
Well, I think the question was, based on what Mr. Parcells learned from the various sources, whether it be neighbors or these internet postings that he found, whether that constituted, in his mind, a lodging house or a tourist home.
That's fine, Your Honor. Because I heard whether or not it was in fact being used in that capacity, and that came in some.
Good point. I don't want to go too far afield if we're still
Okay, so
restricted.
is that the question, basically?
You know what? I'll withdraw that for now, and we
All right,
can
go
come
ahead.
back to that. So stand by. I've got a bunch of questions, and I need to make sure I'm not missing anything here. At what point, Fred, Mr. Parcells, at what point were the photos and web posts that you relied upon to get your probable cause, were those taken, were those posted online? You can review your notes.
I don't know when they were posted per se. I'm not real computer literate, as you and I have conversed about. They were there on whatever day in question I went and looked, and they were there. But when they were posted, I couldn't testify to that, honestly.
If you don't mind referring to page 17 in the book here, you'll see the Shire Society Forum post. You can see post by Pete Eyre on, and then a date there towards the top, just for your reference.
Yes, I'm sorry. I read that into the record. January 4, 2012 at 12:44 and 27 seconds p.m.
Do you have any evidence that the people that Pete Eyre in that case, who made that post, was still living at the home at the time of the raid?
I have no evidence to that effect.
Were you aware that Mr. Eyre and the other tenants who were in the home at that time, or the other tenant rather, in question decided to move out at the end of the very same month where we exchanged the emails? That would be the month of May.
No, sir, I was not aware of that.
Now, you recall talking about the emails that we exchanged in May earlier. When I had asked you in my response to provide me with the evidence, because you had alleged, if you recall, that a lodging house operation was going on the property, I wrote back saying, I don't know what this is all about, but essentially I would like to know more. So I requested from you to provide me with the evidence and the city code that you were bringing up, and whatever evidence you were basing your probable cause on, so I could then present that to the tenants, and because they were still living in the house in early May at that time. But did you ever provide me with what I requested?
No, sir.
Why not?
I don't recall specifically that I can accurately testify to you, but clearly I did not. And I don't know exactly why I did not at that time.
Do you feel like it was bad faith on your part to continue on with this administrative inspection warrant when I was obviously willing to work with you on possibly communicating whatever your concerns were to my tenants?
No, sir.
Well, if you had a communication from the landlord, me in this case, inviting you to continue to communicate about this so the tenants could be informed of whatever this issue is and maybe something could be worked out, don't you think it was an inappropriate move to proceed with getting this inspection warrant?
I do not.
Do you think that's because that this whole thing was actually about creating a pretext to enter my property?
No, sir.
Were you aware that at the same time, approximately the same time, a FBI investigation was proceeding regarding the property at 75 Leverett Street?
No, sir, it was not.
Why were the Keene police involved in the raid?
They were not involved per se. They never stepped foot on your property. They were just in the neighborhood for the protection of anyone who may have needed safety.
Do you think it's just a coincidence that at the same time that the FBI was attempting to gain access to the property by attempting to set up people in an unrelated case about a drug buy, that you were also doing the same thing?
Objection to all of the issues with respect to drugs and whatever. Mr. Parcells has already testified he had no knowledge of the FBI's involvement in the property, Your Honor.
I'll sustain the objection.
So if it wasn't about targeting me as an activist, trying to get into the home, then why not honor my request so I could properly assess the situation? My request for further information.
I testified that I don't recall why I did not provide you with the, I am aware that you know full well how to access the city's website and to pull up that information, but I did not provide it to you specifically.
Do you feel like had you continued on with the emails that, or the information that I had requested, given that I had indicated to you that I was willing to talk to the tenants, that the issue, whatever, if there was an issue, may have been resolved without the necessity of you coming into my home?
Do I believe that would have been the case? No, sir.
Why?
It's my opinion that you have no desire to comply with any government.
I don't think I have any more questions at this time.
Mr. Mullins?
Yes, briefly, Your Honor, on that issue. Mr. Parcells, with respect to your recollection, I'm going to direct your attention back to page number 1 of the documents.
Yes, sir.
You testified to this document already, am I right?
Yes, I did.
Mr. Freeman had at that point refused to allow you access.
Yes, sir.
All right. He does make the request for information, is that correct?
Yes, sir.
All right, and that email is issued when?
May 3rd, 2012 at 11:12 a.m.
Turning your attention to page 3 of the document, sir.
Yes, sir.
You testified to this document as well.
I did.
This was a no trespass order submitted by Mr. Freeman.
Yes, sir.
Did you understand this to require no further contact with Mr. Freeman?
It's a little broader than I believed it to be. I thought it was a more physical presence as opposed to verbal or written communication, but in essence, he didn't want to hear from us. My
Thank you.
opinion.
No further.
Okay, so with regard to this no trespass notice, yeah, this, the first paragraph here, did you want to read that first paragraph on that notice?
As the owner of 73-75 Leverett Street, I do not want any agents, employees, and others associated with the city of Keene, herein referred to as the city, on my property.
Right, so it seems pretty clear that that only has to do with property and not any other method of contact. Does it say anything in that notice about you can't email me or call me or anything like that?
It doesn't state that specifically. It does refer to persistent harassment. One might take writings as a form of harassment.
No, I don't think. I think harassment has specific definitions.
Objection. Your
Okay,
Honor.
well, we're not having a conversation here. Mr. Freeman, if you have any other questions for Mr. Parcells, go ahead, otherwise.
Right, in fact, within this trespass notice, is there not actually a specification that I would like to be contacted if there is some sort of business that needs to be conducted?
Yes, sir.
So I let the means of communication open there, would you say?
Because you could infer that.
What's that?
Yes, Your Honor, although clearly, depending upon where the court goes with this, we may need to have Mr. Parcells come to discuss what he saw at the property after the warrant.
Sure.
And also would reserve the right to call Mr. Parcells at the end of our case in chief in the event that there's any rebuttal necessary.
All right, Mr. Parcells, thank you. You can stay there. All right.
Your Honor.
Again, keep in mind, we're talking about just
Yes, Your Honor.
the issuance of the warrant.
Yes, Your Honor. I call Chief, or Captain Gary Lafreniere to the sitting room.
All right, sir, if you would please, would you raise your right hand? Do you swear your testimony here today to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Have a seat, if you would, please. And would you begin, sir, by stating your full name and spelling your last name?
Gary R. Lafreniere, Lafrenierd.
Thank you, sir. Go ahead, please, Mr. Mullins.
Thank you, Your Honor. Captain Lafreniere, thank you for being here. I understand you're employed by the City of Keene. Could you please tell the court how you were employed by the City of Keene?
Yes, I'm employed by the City of Keene Fire Department, and I had the job of fire prevention officer for about the last 18 years.
And could you please briefly describe to the court, please, what the duties are of the fire prevention officer?
Part of my duties as a fire prevention officer is fire inspections, applying the fire codes, city ordinances as they relate to the fire prevention activities.
Does that include such items as smoke detectors, sprinkler systems, fire alarm systems?
Yes, sir, it does.
And that you're familiar with the life safety code?
Yes,
And you're familiar with state statute with respect to this issue?
yes, I am.
And you're familiar with the city code?
Yes, I don't smoke.
Now, Captain Lafreniere, after May 6th or so of 2012, did you have reason to consult with Mr. Parcells regarding 75 Leverett Street?
Yes, the Keene Fire Department was provided information about activity going on there that may have included changing the use of the structure. It was listed as a 1- and 2-family home, as a duplex, and the owner being Mr. Ian Bernard Freeman, living in 73, and his tenants in 75.
As a single family or a two-family home, if there were no other information otherwise, would you have cause to inspect the property?
No, I would not.
In this particular instance, did you review evidence that was being provided to you by Mr. Parcells with respect to the property?
Yes, we did.
And I think you heard Mr. Parcells go through the administrative inspection warrant. Did you review the photographs that were included in that warrant?
Yes, I did.
Did you include review the other information that was included in the warrant, including the website post with respect to staying at the property?
Yes.
What conclusions, at least preliminarily, did you draw prior to going to the court for the administrative inspection warrant with respect to the use of the property?
That it's a possibility that the use was being changed from a 1- and 2-family home residence to some sort of lodging or boarding house.
Now, Mr. Freeman has represented that RSA 153 does not allow for the inspection of single-family and multifamily homes by the fire department. Is that correct?
Yes.
And is that your understanding of the statute?
Yes.
Is it your understanding of the statute that if you have evidence to indicate that the property is not being used as such, are you prohibited from going into the property to inspect?
No, we have a process to do that by making a request, and in this case would have been an administrative inspection warrant because we were served the notice.
Now, Captain Lafreniere, are you also familiar with the document, turn your attention to page 3 of the document set? you have that in front
Is
of
that
you?
the no trespass
Yeah,
notice?
that's what I'm going to ask you. Are you
Yes.
familiar with that document?
Yes, I was provided a copy of that.
So was it your understanding at that point that you would not be able to go to the property to inspect it?
Correct.
Would that have been your usual course of action?
Yes, we would have attempted to make contact and inspect prior to obtaining a administrative warrant.
Now, in connection with the material that was presented to you through your discussions with Mr. Parcells, I believe you submitted an affidavit to the court, is that right, for the administrative inspection warrant?
Yes, we did.
And could you tell us, tell the court what the basis of that affidavit was? If you'd like to take a look at it and review it, I'll give you an opportunity to do that. Yours appears at page... begins at page 8 of the document set.
Yes, I'm looking at that now. Part of it was our responsibility to ensure compliance with the state and local fire codes and regulations, if that was actually a new use, lodging or apartment house or something.
Well, let me ask you, so the affidavit, basically, you say in the affidavit that there's evidence that indicates a change of use. I think that's what you testified to, is that correct?
Yes.
From your perspective as the fire prevention officer, what would have been required if it were a lodging house or a tourist home?
Under the new use, you would probably have a sprinkler system installed, and you'd probably have a full fire alarm system installed for those applications.
And do those require some permitting authority by the fire department?
Yes, they would.
Were you aware as to whether or not there was any permit issued with respect to those uses?
There was not for that location.
Would that have caused you concern?
Yeah, yes, it would, because there would be an indication that they did not exist.
Now, with respect to the city has a code in place with respect to fire suppression, fire issues as well?
Yes.
All right. And we have to get into that a little bit down the line, but based upon your review of the information, you wanted to determine whether or not there was a fire code violation, is that correct?
Correct.
And from the no trespass order, you understood that you could not go to the property to inspect it, is that correct?
Correct.
I don't have any questions at this time.
Hi, Mr. Lafreniere.
Hello.
So we've already determined you're familiar with RSA 153:14 2A.
I don't know what the exact reference is.
If it's convenient, I'm sure it's probably in here somewhere, but if it's convenient, I have an excerpt here. With the court's permission, I'd like to read that.
(153)(2)A.
Negative. RSA 153:14 2A. Can I read that into the record?
Well, I have it here. I think it's in the front, it's in that material you've got there, sir. It's on page...
Is that about the single-family home?
Page 7 of 15, it looks like.
Do you have that in front of you, Mr. Lafreniere?
I have 2A now in front of me, yes.
Can you read that, please?
The state fire marshal, the state's fire marshal's authorized officers, or the fire chief upon complaint, whenever a state fire marshal, such authorized officers or fire chief shall deem it necessary, may inspect all buildings, excluding single-family dwellings or multi-unit dwelling units containing 2 units, and premise within their jurisdiction.
That's far enough.
No, I prefer that he read the whole sentence.
Okay. and if consent for such inspection is denied or unobtainable, may obtain an administrative inspection warrant under RSA 595-B.
So it's your understanding then that as the fire chief, you are not authorized to inspect what are classified as single-family and multi-unit dwellings containing 2 units?
Correct.
How was 75 Leverett Street classified at the time of the raid?
The inspection took place at a building that was registered as a duplex, 1 and 2 family home.
So, let's see. Were you under orders from anyone to participate in that raid?
Orders from my fire chief, you mean, or?
Yeah, I was wondering if you did it on your own volition as one of the fire
No.
chiefs, or you were ordered to do so?
No, I'm appointed as the fire prevention officer. We obtained information from another department agency, and we joined with our co-inspection of the property.
So did anyone ask you to participate in the inspection?
Yes,
Who was that?
that was what I call the building department, code enforcement.
So was it Fred Parcells?
He was the lead for the housing inspection, yes.
Would you have been able to say no?
Probably not with the evidence that was presented to us.
Even though, as you already pointed out, the building was classified as a single-family.
Right, but as evidence from them was given to us, it didn't look like that was the use anymore.
Are you able to make a legal conclusion like that?
Yes, after an inspection is
After an
conducted.
inspection, but not prior to.
No, we wouldn't have a basis for that opinion at that time.
So just to be clear, you're not able to make that legal conclusion until after the inspection has happened.
Yes,
So therefore, how could you have participated in an inspection on a property that was legally determined at that time, as you've already admitted, to be a single-family dwelling?
Objection is legally determined at that time, Your Honor. The whole purpose for the administrative inspection warrant was to allow the fire department to affirm or dispel the question as to whether the use had been changed.
So, I mean, you're not seriously arguing here, Mr. Freeman, that if you just call something a horse, it's a horse even though it's an elephant?
I'm not sure I understand your question.
Well, I mean, you can call it a single-family property, but if it's really something else, nobody can inspect it because you call it a single-family residence?
Well, no,
Is that-
it's not me calling it that, it's the city's,
Well, okay,
city's
but it's
definition.
basing it on, I presume, what somebody who owned the property told the city about how it's being used.
Well, as I understand it, it's always been classified as a single-family dwelling, and that classification has never been changed. The point that I'm trying to clarify here is that at the time they conducted this inspection, he did not have statutory authorization to be a part of that because it had not been yet determined to be something besides a single-family dwelling. If it had been determined to be something different, then perhaps he would have had the ability to inspect. And that's why I'm saying
With all due respect, Mr. Freeman, that's why you have the court involved. The evidence that would form the basis for whether or not an inspection warrant could be granted was presented to the court, and rightly or wrongly, I guess that's a determination I'm going to have to make, rightly or wrongly, that evidence either rose to the level of sufficiency for issuing the warrant or not. I think people ask police officers, in this case, the fire officer, ask for warrants all the time. Some are granted, some aren't. It was the court's determination that on the basis of the information that was provided, at least, the warrant was justified, and so it was issued.
Yeah, I follow what you're saying
Okay.
there. The point of clarification I would like to make, though, is that as Mr. Parcells testified, they came with what they claim is probable cause about a lodging house being operated. In the objection recently filed by Mr. Mullins, he says that they wanted to inspect the property to see if it was a lodging house and if there were any violations of the fire code. If it were a lodging house, it's never been alleged to be, they've never changed the legal status to a lodging house. I've never been charged with having a lodging house on the
Your Honor,
property.
we're getting into the second phase of this discussion.
But they're trying to mix-
With all due respect.
with respect to whether or not the zoning administrator went forward with the lodging house complaint. That's different than the fire code issues.
But without the change from the single-family dwelling status, he is not authorized to inspect. It's always been a single-family dwelling. Had they wanted to say it was a lodging house after inspecting it, they could have made that claim. But they have no evidence for that, otherwise they would have brought that charge. And at that point, had they actually changed the status, then perhaps he would have been legally authorized by statutes or by a judge to be able to come in and do that. But they never changed the status.
Well, the only thing we're looking at this point, Mr. Freeman, is whether or not the warrant that was issued was based on sufficient evidence to do that. What happened after they got in there is for further evidence to be introduced. But
Right,
at this point, all we're talking about is the sufficiency of the warrant.
Right, what I'm suggesting is that the portion of the warrant authorizing a fire inspection was the part that was inappropriately issued, because it had not, the
Well,
status hadn't been changed.
I understand that's your argument, yes.
Okay. Let me see if I've got any more questions for Mr. Lafreniere. So just to go back to where we were, when Fred Parcells came to you and told you about this situation, would you have had the ability to tell him, no, that seems inappropriate, I don't want to participate in that?
With what was presented to us, looked like a violation. It was a possible change of use of the structure, and that's what we were trying to ascertain. So no, at that point, I would not have been able to walk away from it.
Is it
I would have to follow up on it.
Is it your task as a fire chief to ascertain whether the change of use has occurred, or is that the zoning enforcement?
It's probably a little bit of both, but we have in the fire code a change of use. Because once a structure changes its use, we have to review it for fire code application.
Of course, at the time that you were presented this, there wasn't enough evidence to actually change the use of the structure, correct?
Objection, Your Honor. The court understands. But it's not-
I understand the issue here, Mr. Freeman.
Okay, as previous with the last witness, I still, if this trial goes on, I would still like to ask some other questions. But no further questions on this matter.
John, anything else?
Well, I do, Your Honor. Unfortunately, it's a bit out of sequence. What I would prefer to do with the court's indulgence is to recall Mr. Lafreniere after we finish with the zoning administrator, because that's how we got into this process. And I can explain to the court, Mr. Freeman, the decision of the zoning administrator, but Captain Lafreniere still has an independent obligation. We need to walk through it now and bring the zoning administrator back up, and I guess I'm a little...
Well, have we introduced all the evidence you want to introduce?
Oh, yes, Your Honor.
Sufficiency?
Yes, Your Honor, I apologize for that, yes.
Okay.
Yes.
So do you have another witness of any sort you want to introduce on that issue?
No, Your Honor.
Okay. Any other questions for
No thanks.
the officer about that issue?
On that issue.
Okay. Thank you, sir.
Thank you.
Okay, so we're at the point of determining whether or not the issuance of the warrant was sufficient?
That's now submitted to the court for its determination as far as the state's decision.
Okay. Well, what I need to do at this point, before ruling on that, is look at pages, whatever it was, 4 through 22, which I have not seen previous to today. So I think to go farther than this today really doesn't make any sense. I think I need to review that, make an order about the sufficiency of the warrant, and then, depending on how that goes, we either proceed or we don't.
I agree.
It's up to the court.
Okay. So I'm going to take that issue about the sufficiency of the warrant under advisement.
Thank you.
Based on the written order that I make about that, we'll either proceed further or we won't.
I guess you do have my motion here, which is basically my memorandum
I do,
on that,
yes.
on that issue. And can you please take under advisement that I will be traveling some more within the next few weeks, so my schedule will be fairly limited in the month of June. So as far as a follow-up hearing, I would prefer it be early July is fine, but sometime in July would be.
I don't think there'll be a problem with that, Mr.
Okay.
Freeman.
Thank you, sir. I appreciate it.
Your Honor, please recall as well, Mr. Freeman did submit that motion to dismiss based upon the constitutional provision, and I don't believe the court has moved on that yet.
No, I will also take a look at that as well.
Thank you, Your Honor.
All right, thank you.
Thank you. Now.
Court, non-recess.
Just ask, emailing address is the same as ours, right? Okay, because what I'll do is I'll reset this. I send out a notice. If that doesn't work.
Oh, sorry.
If the notice doesn't work for either party, it'll reset date. Somebody let me know.
Clearly, obviously, the first week of July is not great for anybody.
Well, the issue we've got obviously is that Judge Runyon's over here, usually one day a month. Generally, it's the end of the month, so likely it will be the end of July. Honestly, I can't recall. Well, I can't recall the dates he's here. He's here at least once a month, so that's from July to the end of August.
I've got 3 cases open right now anyway, so.
I guess what I'm getting at is I don't want to make you guys. I'll send out a date. If it doesn't work, just call me, email me, whatever, call me. And look the date out.
Call me. Ask me about the send it.
If we're going forward based on everything, all I would do is send out these decisions along with a notice of the hearing date.
Yeah, you gotta drive. They do give you $20 a day for gas.
Yeah, that's not happening.
We'd like to invite you to visit freekeene.com. Freekeene.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeene.com also has comments and discussion forums so you can be heard. Freekeene.com.
I should be in Keene, New Hampshire with the Free Staters.